Nurturing talent. Internships can provide a wonderful opportunity for a young person to get on-the-job training, but employers need to understand their responsibilities to interns. By Mark Phillips. This article in 1, 2, 3. 1. Australia's Fair Work Act does not contain a definition for internships, and common law leaves room for uncertainty. 2. As a result, despite their many benefits, internships can become a legal minefield if not entered into with care. 3. The Fair Work Ombudsman states that employers cannot avoid paying lawful entitlements to employees simply by calling them interns. Australia's accounting, consulting and professional services sector has long had a reputation for offering some of the best internships. In the 2019 Top Intern Program study, created from a survey of over 1,300 undergraduates who were part of an intern program over 2018 to 2019, 8 firms, Shinewing Australia, PwC, Pitcher Partners, Accenture and KPMG among them, were listed in the top 40. Of course, it's not only large firms that offer internships. Many accounting majors see benefits in interning at small to medium practices because of the greater opportunity for exposure to the day-to-day workings of an accounting firm, instead of perhaps just 1 or 2 aspects. The downside is that smaller firms tend to operate with limited time, budgets, and personnel. Despite the best of intentions, internships can become a legal minefield. Internship is an American term and has no meaning in Australian law, says Luke Forsyth, Hall Payne Lawyers Principal. Quote, "The majority of internships operating or being advertised are probably unlawful. What our law recognises is vocational placement." End quote. In February this year, legal action brought by the Fair Work Ombudsman made this especially clear, with $329,133 in penalties awarded against a fashion industry startup for underpaying 3 workers by more than $40,000. Sydney-based Her Fashion Box Proprietary Limited was penalised $274,278 and its sole director a further $54,855 in the Federal Circuit Court of Australia. One of the employees worked 2 days per week for almost 6 months without pay under a so-called unpaid internship before receiving a one-off payment of $1,000. She was underpaid $6,913. Business operators cannot avoid paying lawful entitlements to their employees simply by labelling them as interns, Sandra Parker, Fair Work Ombudsman, says. According to Interns Australia, internship providers often treat internships as a novel, unregulated relationship. Increasingly, they are seen as a channel for gaining labour without the costs and other obligations that come with hiring an employee. Quote, "Our research indicates that most university students complete multiple internships. Most are unlawfully unpaid or underpaid, with the average intern losing $6,000 in wages over the course of their internships." End quote. Accountancy firms taking on interns as part of their CPA are probably okay, as long as they're doing it to complete their qualifications, Forsyth says. Those taking on work turns, which is not defined under Section 12 of the Fair Work Act 2009, need to be aware that they are entitled to a minimum wage. Quote, "In most cases, I don't think people do this deliberately. They just don't know. But to the extent that smaller accounting firms are taking on interns in sections such as accounts receivable, it's simply not working. They might describe it as work experience, but there are a lot of people out there doing junior admin for free on the basis that they're going to get a job." End quote. That may or may not come to fruition, but things can get ugly if the relationship sours. If you have engaged someone as an intern and employed them later on, if the relationship goes south, they will come and see someone like me, and I'll ask how long they were engaged as an intern, Forsyth says. Quote, "They're entitled to claim the money they weren't paid, which makes it worthwhile bringing a claim against their employer. The reality is you're creating a potential liability for yourself, which is not just having to repay unpaid wages and entitlements. If they make a complaint to the Ombudsman, under the Act, a business can be liable to pay up to $63,000 per contravention. When engaging an intern, you can end up contravening the Act in 3 or 4 different ways. all carrying separate fines. Eventually, you're going to get done. Unless they are legitimately part of a vocational requirement, internships are best avoided." End quote. Although the Fair Work Act does not define an intern and common law leaves room for uncertainty, according to Melbourne-based employment lawyer Peter Vitale, there are important considerations for all principals. "I use the neutral term principal rather than employer," Vitale notes. Quote, "All of the issues will be determined by reference to objective evidence, not the arrangement the parties thought they were entering into. Documented arrangements calling the relationship an internship are of limited value if the objective facts contradict that proposition." End quote. Breakout. Points to consider. Employment lawyer Peter Vitale puts forward 6 key points to consider in internships. 1. Whether or not the parties intended to enter a legally binding contract, which is an employment contract. 2. Whether the intern is under an obligation to attend the principal's workplace or free to come and go. The former is more likely to indicate an employment relationship. 3. Whether the so-called intern is performing productive work that benefits the principal. If so, it is indicative of an employment relationship. 4. Is the main purpose of the intern's presence to observe and learn, which might indicate no intention to create an employment relationship, or are they performing work normally performed by employees of the business? 5. What is the length of the arrangement? Any arrangement of more than a day or two is more likely found to be employment. 6. Is the intern on a placement required as part of a legitimate vocational training course or school work experience? If so, under the Fair Work Act, the intern is not considered an employee and therefore not entitled to any of the entitlements of an employee. For businesses looking to engage trainees on an unpaid basis, my recommendation is, unless they come as a requirement for a formal training course, don't do it, Vitale warns. The Fair Work Ombudsman is very vigilant about these issues. Quote, "The legal uncertainties and substantial penalties for getting it wrong mean that a prudent, risk-averse business should play it strictly by the book." End quote.